appeal of Jean-Rony Jean-Charles against the Honourable Carl Bethel and for others.
Yes, my Lord, my Lady, I appear with my learned friend Frederick Smith of Queen's Counsel, Dawson Malone, my learned friend Adrian Fremont for the appellant in this matter, my learned friend Mr. Tom Poole of Queen's Counsel, and my learned friend Kayla Green-Smith, the Assistant Director of Legal Affairs, appears for the respondent. My Lord, the course I propose to take is firstly just to very briefly summarise an overview by reference to the case at paragraphs 1 to 7, then to take you through the statement of facts and issues, and then to deal with each of the 4 grounds of appeal in a little more detail. My Lord, that's my proposed course.
There doesn't seem to be really much between you and Mr. Poole as to the law at all.
No, not on the law, no, my Lord. I think a lot depends on the facts. I agree, my Lord.
And as far as the facts are concerned, we don't really know what the facts are because there's very little evidence.
Well, my Lord, I respectfully submit that the return does make fairly clear what the position is, and so
we don't know who the appellant is.
What, sorry,
we don't know who the appellant is.
My Lord, can I respectfully deal with that right at the start? If I can take the court to the birth certificate at paragraph 24. Sorry, page 24. Page 24 of the record. If I can take the court to that right at the start.
If you could hold, just wait a moment.
So, my Lord.
I'm still not with you.
I'm so sorry.
I'm sorry, just having to open this up and put in passwords and all the rest of it.
Oh yes. Okay. Well, it's EB page 24.
Yes.
Yes. So, my Lord, we say that at the end of the day, the answer is relatively simple. One sees there Charles' surname, Jean-Charles, and his sister is Jean-Charles. Charles' Christian name, Jean-Rony. So he is Jean-Rony Jean-Charles. His first name is Jean-Rony, his second name is Jean-Charles. And that is the birth certificate. There really is no dispute that he is the person who was detained.
Well, you say there's no dispute, but I understand Mr. Poole does dispute it.
Well, my Lord, I'd like to, we say it's not capable of reasonable dispute, if I can put it that way, my Lord. The person there, Jean-Rony Jean-Charles, who the respondents accepted was the same person as who was first detained and then expelled.
Well, do they? Is that right? I thought the respondents accepted that the person who was detained was returned, but the respondents do not yet, and quite why this hasn't been clarified by the time the case comes to us, I do not know, but the respondents do not acknowledge that the person whom they detained and returned was Jean-Rony Jean-Charles.
Well, my Lord, can I, because obviously our case is that there is no reasonable ground to doubt this, and that the judge simply was saying, when he made the remark about, well, one can't be absolutely sure, that one can't be absolutely sure, but nonetheless did the right thing, which was to do what the best thing he could on the evidence and on the law.
What evidence did he have?
Well, my Lord, if you have an affidavit from the sister saying, my brother, Jean-Rony Jean-Charles, here is his birth certificate, and there we have his birth certificate. He is the person I've been, as it were, camping outside Carmichael Detention Centre trying to get access to. Then we're told that that person who is the subject of the application has in fact been deported and they say it is the same person. Then papers are issued by the government, temporary papers for Jean-Rony, Jean Charles. Mr. Frederick Smith and others go to Haiti and find Jean-Rony, Jean Charles and bring him back. And then he's detained as Jean-Rony, Jean Charles.
Well, you're telling us this.
Well, my lord, that's it.
Is it not a matter that has to be decided in the proceedings in the Bahamas?
Well, my lord, we say it has effectively been decided by the judge, and there's no reason that the captious and over-technical approach of the Court of Appeal simply doesn't hold water. When you look at it, there's the birth certificate of someone whose first name is Jean-Rony, whose second name is Jean Charles. So he is Jean-Rony, Jean Charles. We know that he was detained. We know that he was deported, and we can see that, my lord, if you look at page 362, then the judge's judgment. So 362. There is the surrender order, which was relied on, which the judge said was unlawful. The Director of Immigration on page 362, if the court looks over the page, item 31 at page 363, Jean Charles, a.k.a. Jean-Rony. In fact, he is Jean-Rony, Jean Charles, and they know he's born in Nassau, Bahamas. They give a different birth date, but there's no doubt, there's only one person called Jean-Rony, Jean Charles in the birth certificate and in this. And we say that this is it with the greatest respect to the Court of Appeal. It's simply not capable of reasonable dispute, nor was it by the time the matter was before them. The respondents themselves were saying their whole case was the person you're kicking up a fuss about Jean-Rony, Jean Charles, has been deported. And they produced this document which refers to Jean Charles, a.k.a. Jean-Rony, against the background of a birth certificate, which makes it clear that there's a person called Jean-Rony, Jean Charles. Who else could it be? It's simply not capable of reasonable dispute. And for, as my Lord Hodge said, for 4 years, for the government to be refusing to accept the obvious is defeating justice. And this court should not say, oh, well, if you don't agree, therefore with great respect, it's obvious. And so we respectfully submit they cannot and reasonably dispute that matter.
On one view, on one view, Ms. Fitzgerald, this is really an issue of simply of case management we're dealing with. That the Court of Appeal felt that because there were that the issues relating to the alleged breach of the Constitution required to be litigated in proceedings begun by writ, which would allow for discovery and so forth, leading of evidence, rather than determined in a summary way on the basis of a motion.
Well, my Lord, my respectful submission in response to that is that the judge behaved entirely properly. He recognised that there was I mean, this hadn't come from nowhere. There had been a month on the 29th, the summons was issued, and there were emails exchanged with the government on the 6th of December, in which Mr. Frederick Smith had set out the case that this was unlawful detention if he was detained, but was saying, I want to know whether he is still detained here. The night before the hearing, the respondents produced the return. The return reveals that somebody called Jean-Rony, a.k.a. Jean Charles, a.k.a. Jean-Rony, my lord, has indeed been expelled, and they say that's the person who you're seeking. So he's there. The judge then has the difficult position that someone who, on the face of it, has been unlawfully detained and unlawfully expelled is in Haiti He's clearly, from all the facts, not someone necessarily capable of looking after himself very well.
Well, that's something that we had wondered about, reading between the lines
Well,
here.
my Lord, you can see his signature, but my Lord, that's... So, my Lord, that's the thing. That's exactly when the judge has to fashion a remedy. This person is in Haiti. He could be killed tomorrow. He should be in Bahamas. We've got to do something about it, not allow procedural points about we're not entirely sure who this person is, or we're not entirely sure about whether we might have some justification, although we've got none that we can produce to this court. No, act now. Delay of justice is defeat of justice. Ubi ius ibi remedium. The judge did entirely the right thing, and all the Court of Appeal do, we respectfully submit, is to engage in a series of rather technical and barren points to defeat the entirely just decision of the judge, without which he would have still been in Haiti. And God knows what would have happened then. So, my Lord, I do respectfully submit that the judge was at his instincts. He says at paragraph 5, I've got to do it. I've got to do something. I can't be absolutely sure who he is, but really, my Lord, if one looks at it, birth certificate, Jean-Rony, Jean Charles. Expulsion certificate, Jean-Rony, Jean Charles. No alternative explanation, no justification whatsoever for the detention, and we respectfully submit the judge did the thing that he had to do, which is, in the face of injustice, I'm not going to allow procedural points to stand in my way. And my Lord, it's not as if the state had not had notice. They'd had notice on the 29th of November, when the summons was issued. And my Lord...
Well, that gave them notice of the habeas corpus application, but did it give them notice of the claim for compensation for breach of constitutional right?
Well, it was the question of it being unconstitutional was stated by his sister in his detention is unlawful and unconstitutional. But, my lady, can I just make this point? If one looks at the Ramatullah jurisdiction, which my Lord Reid, of course, gave judgment in, there is very little difference between a habeas corpus jurisdiction saying you've got the person, or you have the person and you may have influence over getting him back, and the constitutional motion in this case. In other words, the issue in the habeas was, has he been unlawfully held? Can he be lawfully expelled? And should he be brought back to see Ramatullah? The issue in the constitutional motion was he unlawfully held? Was he unlawfully expelled? Should he come back? They're the same issues in the end. So I respectfully submit that all this nitpicking about habeas corpus finishes and then you have to start again, the two, and this has been recognised by your Lordship's board on numerous occasions, there's an overlap between habeas corpus. It's in Lord Brown's judgment in Oldham Justice's ex parte Corley. It's in the Knowles case where Lord Stayne gave judgment. The idea that we had no idea, look at the return. They don't just say he's gone. They set out, they put their best foot forward, and they set out in some detail all the points that they can make about what's happened, how it happened, etc. And if there are points of law, the respondents never asked for an adjournment. They never said, please, can we have an adjournment? They took their chances. They took a point on the proviso to Article 28.2, and they lost. And we do very respectfully submit that whilst at first blush one can say, oh, well, this was all a bit sudden, actually, you can see the judge referring to the fact there's been press reports. That, I mean, this was not something that was suddenly, oh gosh, we've got to justify his detention and expulsion. We've never thought of it before. This was very much in the public domain. This was very much the sister from the 29th of November saying he's unlawfully detained. Mr. Frederick Smith in the emails exhibited to the 6th of December document saying he's unlawfully detained if he's been deported, then it would be unlawful, and he cites section 40, cites section 41. They had all that on the 6th of December. They were there in court when he got leave to issue the writ. But they just said, we have no instructions to appear, but the representative of the government was there. They had the email the night before. And then what do? They put in a return which very fully answers all the points. In other words, if you look at the return, which it's not as if they don't put their best foot forward in their return. So here it is. I, Katura Ferguson, not he's no longer with us. That's the end of it. Push off. It's look at the schedule 52. I declare, in obedience to the writ, I herewith certify and return without prejudice that by way of explanation, during routine patrol in the area of an adult male was interviewed by officers of the department. The said Haitian gave his name John Charles, age 31, his date of birth 85. Well, that whether he did or not, we're stuck with that statement at the moment. But it's questionable whether he'd forgotten his own birthday. But he was Jean Charles. It's just like if I say Fitzgerald and they say, oh, there's a problem about whether Edward Fitzgerald is Fitzgerald. I mean, it's just ridiculous. The said Haitian national was not able to provide any documents or any proof as to his lawful presence in the Commonwealth. He was taken to the Carmichael Road Detention Centre for further investigation relative to suspected contract. There's absolutely no offence that has been identified, and he was held there for 2 months.
He doesn't have to have committed an offence to have been lawfully detained.
Well,
Under Section 19 of the Constitution, you can detain someone, can't you, for the purpose of preventing the unlawful entry of that person into the Bahamas, or for the purpose of effecting the expulsion, extradition or other lawful removal of that person, or the taking of proceedings relating thereto. Now, are you saying that the return indicates that the government was accepting that his detention for the purpose of bringing proceedings or effecting his removal was unlawful? Because that would be the issue that doesn't really... would be key for the redress. Yes,
my lady. Effectively, in saying it's relative to a suspected contravention of the Immigration Act, that's their justification. He was detained relative to... If you are charged, we've done that in our further note, which I hope the court has, but if you are detained, and the judge sets all this out, if you're detained on a suspicion of an offence, then the position is that you have to be charged and brought before a magistrate's court within 48 hours. That's Section 18 of the Criminal Procedure Code. And under the Constitution, Section 19(3), you must be brought before a court without undue delay. So if and this is their case, he was detained for further investigation relative to suspected contravention of the Immigration Act. That's to say, an offence.
Well, no, because if you look at 19(3), the bringing before the court is only in relation to subparagraph 1C or D of the article.
Well, that's a criminal offence, my lady. A contravention of the Immigration Act would be a criminal offence, and that's why they use the word suspected contravention of the Immigration Act.
Well, they might simply be saying unlawful entry into the Bahamas.
Well, my lady, they have never said, over these last 4 years, there has not been one scrap of evidence to suggest an unlawful entry. The affidavit of his sister says he was born here. Their own documents say he was born in Bahamas. If you're born in the Bahamas, you either become a citizen of the Bahamas by virtue of registration, or you are given permanent residency status as a matter of legitimate expectation, and that is the policy. So there would be no basis immigration basis, but in any event, if there was going to be some deportation, where's the order? Where's the order for his deportation? You can't just have some official saying, I think we might want to deport you, so we'll hang on to you until for 2 months, and then an immigration director will... As the judge said, there's no authority for an immigration director to deport. And so, my lords and my lady, what we respectfully submitted, can I just, while we're there, just take you through that, the schedule? Because this is the answer in our respectful submission to the point there is no evidence on which the judge could act, because he did act on this. The said Haitian national, well, he's...
Where are you
I'm so sorry, my lord, page 52, my lord.
52.
Yes. They keep saying he's a Haitian national, but he was born in Bahamas and certainly had the right of residency, or the legitimate expectation of residency.
Do you have a right of residency? I mean, you're telling us a lot of things that we don't know from our other sources. Do you have a right of residency automatically, or do you have to apply for some sort of recognition of your right?
There'd be a legitimate expectation. My learned friend, Mr. Smith, that because there's a policy. Can I just show your lordship? So
he would have a legitimate expectation that he would be granted a right of residence if he were to apply for one.
Yes, my lord. Yes, that's the position. Okay, my lord, can I just show you 1568? You can see the articles 6 and 7. We know from their own case that they accept he was born in the Bahamas.
I'm sorry, where are you looking now?
Page 1568, my lord.
What are you looking at?
The Constitution. Every person born in the Bahamas after 19 shall become a citizen of the Bahamas at the date of his birth. A person born in the Bahamas after 9th of July 1996, neither of whose parents is a citizen of the Bahamas, shall be entitled upon making application on his attaining the age of 18 years or within 12 months thereafter, in such manner as may be prescribed to be registered. So that's the right, and we accept that he wasn't registered. However...
I'm sorry, I've got the page, 1568, but which article?
6 and 7.
6 and 7, my lord.
So he didn't become a citizen because neither of his parents was a citizen at the time, is that right?
And he didn't register.
No, but I mean, if either of his parents were a citizen, he wouldn't have to register.
No, that's right, my lord. Yes.
So 6 is irrelevant.
No, my lord, that's absolutely right. It's 7-1.
7-1 is the situation that we have a young man whose parents weren't citizens of the Bahamas, but who grew up there and had a right to apply for citizenship when he was 18 or within 12 months thereafter.
Yes.
Well, in fact, he didn't, though. And if he's a Haitian national, then the proviso to 7-1 says that he has to renounce his Haitian citizenship first.
Well, no one suggested that he is a Haitian national.
Well, on his passport, on his emergency travel document, it says he's a Haitian national. Is that not right?
That was issued by the government, but they never disputed that he was. They never disputed his birth in Nassau, my lady.
No, but he must be a nationalist
somewhere.
Well, my lord, he is someone who. My lord, can I just put it this way? He's never been, as it were, granted citizenship by Haiti, and he wasn't even born there, never lived there in his life. But my lords and my lady, the point I'm trying to make is that he would, and my learned friend Mr. Frederick Smith, who's a great expert on this, has assisted me. Because obviously it's a bit tough if just because you don't register during the years 18 to 19 you don't get citizenship. There was a policy to let you, as it were, catch up. That has been, and therefore you could register later. Subsequently, the policy is simply that you're made, that if you apply for permanent residency, you get it. If you were born and you would have qualified. That may be important, obviously, to the question of remedy at the end of the day. My lord, so that and we can produce the policy statement if necessary. My lord, my lords, my ladies, what I'm trying to deal with is the question of the adequacy of the information that was before the court. And so, my lord, if I can just take you through the position as per the return, which is set out at page 52 onwards. So he's detained for suspected contravention of the Immigration Act, an investigation. We respectfully submit that if as a suspicion that you've contravened the Immigration Act, you must then be prosecuted for that. If you're prosecuted, then the Constitution, section 19(3), any person who is arrested or detained in such a case as mentioned subparagraph 1c, for the purpose of bringing him before a court and execution of the order of the court, or upon reasonable suspicion. So it's D, my lady, it's reasonable suspicion, because that's what they're relying on. And
why do you have to be prosecuted?
what?
If you're present in breach of immigration law, why do you have to be prosecuted?
Well, because somebody's got to find that you are in breach. I mean, there has to, and the judiciary obviously have to make that finding. The executive can't make a finding that you're guilty of a contravention of the Immigration Act. It has to be
Why do you say it has to be a criminal offence if it's a contravention of the Immigration Act? It's coming to, according to Mr. Ferguson or Miss Ferguson, they thought that he had just come to the Bahamas.
Well, it says for further investigation relative to suspected contravention of the Immigration Act. And that sounds, in our respectful submission, as bringing in question the powers in section 9 to arrest. You can't arrest. An immigration officer has the same powers as a constable to arrest for a suspected breach of the immigration rules. And that's the part. I mean, if you say, why are you arresting this person, that's the language they use. They say they arrested him.
When you think about how things are done in the UK, the executive arrests, the executive serves deportation order, the executive will deport. The courts only become involved, or tribunals only become involved in an appellate case.
Well, my lord, if there's a deportation order, then that has to be at the ministerial level and it can't be given by the immigrant. But what the point we're respectfully making here is the language. If you look at page, again, EB 56, he was arrested on a routine status check, was asked to produce documents, had no documents possession, subject was brought to detention. It is for further processing, yes. And my lord, so what we say is either you are prosecuted for a contravention of the Immigration Act, in which case you must be brought before a court and charged within 48 hours. Or if they're going to go down the deportation route, the only person who can give an order for deportation is the minister. That's section 40. And the only person who can give section 40 of the Immigration Act, the only person who can give ordered detention pending deportation is the Governor General, and that's section 41, subsection 4. And so, and there are cases on that, such as Jean Charles, about the procedure that must be followed. Sorry, not Jean Charles, I'm sorry, Jean and the Minister of the Interior. Not Jean and the Minister of the Interior, which we've cited. But if I could, so we have the bit about the wrong date, and then we go on, a subsequent check of birth records. Well, they made that check actually after he'd been deported on the 7th, so on the 7th of December, and after they'd been served with the habeas corpus writ. They say there was no record or any other evidence presented or subsequently uncovered. Well, that's because although his sister says she went and gave them all the materials, they then said they'd lost them. who identified him as Jean Charles, she deposes to the fact that she provided them with all the relevant documents. Said Jean Charles, so again, it's just a surname, subsequently safely returned to his home country, the Republic. I mean, that is just the worst of Orwellian euphemisms. He never lived there in his life. They had his birth certificate provided by his sister. The said Jean Charles again confirmed his identity, Jean Charles, date of birth during a roll call. Well, we really don't know, but that's hearsay on hearsay. But let's assume that he says, yes, I'm Jean Charles. He was Jean Charles. It'd be like me saying, yes, I'm Fitzgerald. They had a team of escort officers from the Department of Immigration, the Royal, also travelled on the bar, so he was forcibly taken there. Accordingly, the subject identifying himself as Jean Charles, a Haitian national, had been released and has safely departed the custody and control of the Bahamas. The material time, 13, there was no record confirming or reason to believe, based on he provided the authorities and or the subject of this writ therein, are one and the same person. Well, my lords and my lady, they already, at the time of the hearing, they had Clotilde Jean Charles's affidavit, and she deposes to the fact that she had been going repeatedly during the 2 months between September and November, presenting the documents. Can I just take you to them? And the court can see at page 20, Clotilde Jean Charles, I am the sister of the applicant. I'm authorised to make this on his behalf. I swear this affidavit in support of Jean-Rony's application, so that's Jean-Rony being his first name. The facts are set out herein. Jean-Rony was born at Princess Margaret Hospital and is entitled to Bahamian citizenship. Well, he would be entitled if he had registered. A copy of his birth certificate is exhibited. He's never travelled outside of the Bahamas. Despite this, he was unlawfully arrested by officers of immigration on or about early September. He's committed no offence under the Immigration Act. He's presently falsely imprisoned. Since his arrest, I've taken documents proving his birth to the Department of Immigration upon their request, but I still have not been able to secure his release. Jean-Rony's family members and I have made numerous attempts to secure his release and are being told that his matter is being investigated, whatever that means. Jean-Rony's family and I were recently advised by Mr. Roll of the Enforcement Unit his documents which were submitted could not be found. It's now almost 12 weeks since he was illegally arrested and falsely imprisoned. He's not been charged with any offence. He's not given bail. He's not been taken before any court. He has not been served with a deportation order. And that's really important in our respectful submission. Despite numerous attempts by me and his family to secure his release, he's still unlawfully imprisoned by the Department of Immigration. I'm advised by counsel to Jean-Rony that the respondents are not entitled by law to falsely arrest and falsely imprison, and his imprisonment is unconstitutional and unlawful. Nothing could be plainer that in the habeas proceedings, and we don't accept that the habeas is as narrow as was suggested, he was saying, I'm unconstitutionally right from the 29th onward. If we go on from there, she then exhibits the birth certificate. You would have thought that anybody with any concern for the rights of this individual, who's, my lord has observed, it's obviously he has some limited ability to fend for himself, would say, well, let's check out Jean-Rony Jean Charles, and they would have found that Jean-Rony Jean Charles actually existed and had a birth. But instead of which, they do absolutely nothing until the bird has flown. And then on 7th of December, they put in Jean Charles. They put the wrong date. I think they put the 1st of December 85. And they come up with, oh, there's nobody there. Well, we respectfully submit that and you see, can I then just take, because this was further, so that's the material before the judge. We say, faced with that uncontradicted assertion, faced with the 3 weeks that had elapsed, and faced with the return, one would say no order for deportation has been produced from the minister. No criminal proceedings have been initiated. Where is the authority? They've identified nothing. They've just said there might be some authority. We want to argue it in 4 years' time. And my lords and my lady, if we go to Kira Martin's affidavit, which was before the judge at the 7th of December hearing when he issued the writ, Kira Martin, counsel and attorney in the Chambers of Calendars.
Which page?
It's page, sorry, my lord, EB 27. Shall I just take you to the key bits, my lord? So she says, within my own knowledge, at 4, there is now produced and shown to be the email correspondence from Mr. Frederick Smith to the Minister of Financial Services, Jon Brent Simonet, and the Director of Immigration. So all of them had been contacted and alerted to the issue, and we know from the judge that it had also featured in the press. And then if we go... Yes, okay. Yes, so if I take you to, first of all, you see on the 4th of December at page 34, I am at the Carmichael concentration camp. I'm attempting to see my client. I was told by the immigration officer at the gate, that's page 34, my lords and my lady, to make an appointment, and then he then gets, as it were, seized and removed. And he makes the point at the bottom of page 35, as an attorney, I can go to any police station and or Fox Hill prison and I will be respectfully accommodated by those in charge to be allowed to see a client. So they don't tell him there, well, actually, he's not here. But clearly he's drawing attention to the injustice. So they're fully aware of it. And if you look at page 30 itself, there's a detailed letter to the Minister in the Department of Immigration.
30?
At page 30, EB 30, my lord.
33.
Yes. Do you see the email there, my lord?
Yep.
And you can see there, I asked to see a deportation order. He's then told he's been deported. And understandably, there was some suspicion as to whether this indeed had happened, but we now know he had been deported. I asked to see a deportation order. Said there was not one, and that he'd not been deported. He'd been repatriated. You can't just repatriate someone. If you're forcibly taking them, you've either got to have an order justifying that, or you've got to have criminal proceedings resulting in a finding of a contravention. You can't just pick people up and ship them out on the say-so of the Director of Immigration. Page 31. As you will note from Clotilde's affidavit, my client was born in the Bahamas and has never travelled abroad. His 5 siblings are all citizens of the Bahamas. JC was born in the Bahamas. Then one sees the information provided by the DO that he's told that he'd been removed, and he says that the family were never told that. No time were they told that JC was to be removed from the Bahamas. Then he sets out the basis of the constitutional challenge, which is brought 2 weeks later. Article 25 of the Constitution guarantees every person immunity from expulsion except under the authority of the law. The relevant law that allows for lawful removal of a person is this Section 40 and subsequent provisions afford due process and the right of appeal. Expulsion, repatriation, deportation or removal by whatever name they want is completely illegal in the first instance unless a person falls into the categories in Section 40, which is the only legal basis upon which a person can be removed from the Bahamas. And then he makes the point about a person who is born in the Bahamas cannot be removed from the Bahamas simply because they have not been issued some form of status or papers. He has a birth certificate, has lived in the Bahamas all of his life. And then it was his 35th birthday, and I think there were some emotional scenes outside the prison when his sister tried to visit on his 35th birthday. And those were widely reported in the press. They therefore, in our respectful submission, had full notice of the fact that if he had been expelled, and now it's quite clear he had, the appellant's lawyer was saying that would be unconstitutional and saying, where is the deportation order? Now, the next day after he sends this letter, December the 6th, he goes to court, and at court, Mr. Fred Smith gets the Frederick Smith gets the cites the matters to the judge and gets the judge to issue the writ. My lord, I can just pick you up there. It's in the SFI at page 1465, my lord. Judge granted leave to issue the writ. The writ was issued. Now, at that hearing of the application for the return, I think it's at page 181, but I'll be correct. Yes, page 181 to 182. You can see that Mr. Smith says, Mr. Francis is counsel. Gary Francis is counsel for the Attorney General. But Gary Francis is counsel for the Attorney General, and one sees at page 181 at line 16, and I have something to say that Mr. Francis, when I first came in, I'd like to apologise having come late. Mr. Gary Francis and I were discussing whether or not he would simply consent to the application, because this is just an application. So they were on full notice. The day before he set out it's unconstitutional. This day he's having discussions with Mr. Gary Francis about it. And one sees, yes, we had given them notice at the top, it's ex parte, but he's given them notice at 182 and at line 9. And having regard to the fact that it's an ex parte application and giving notice to the Attorney General, I sent them an email in which I outlined certain things and I asked for a response to certain things which I have not received. Important point which I make in that regard is that I said to the respondent in that email, as you were aware, habeas corpus proceedings, because the email had been appended to the affidavit of Kira Martin, which was before the judge. I attached copies, etc. I have an obligation, as it is an ex parte motion, to make disclosure to the court of all relevant facts. I will be attaching a copy of this email, so there's simply a short affidavit attaching my email, and the judge says that at that stage, I don't believe that is necessary. Be on file, my lord. And then he goes on, more than 48 hours, the authorities either justified the detention or that he be released. So either he's going to be charged with a contravention, a criminal offence of breaching the regulations, or for one of these specified grounds under Section 40, a deportation order is issued. And there are cases in the Bahamian courts saying it won't do if someone else other than the minister does it. That's Jean and the Minister of the Interior. It's got so one sees if one goes in the Immigration Act, which is EB 1598. What he's referring to in the emails and referring to before the judge is at the bottom of under Part 8. If at any time after a person other than a citizen of the Bahamas or a permanent resident has landed in the Bahamas, it shall come to the knowledge of the minister that such person, A, has landed or remained in the Bahamas contrary to any provisions of this Act, B, has been convicted of any offence against this Act or of any other offence, C, is a person who is present that is undesirable. The minister may make an order requiring such person to leave the Bahamas within the time fixed. And then where a deportation is made, there's a right of various procedure. A copy of the order shall be served upon him by him, so he's got to be served. And there's authority in the case of Jean and the Minister of the Interior that you can't do it orally, you've got to do it by a written notice. And then as to detention, the detention has to be authorised by the Governor General. See subject C41.
Sorry, what are you reading from now?
So section 41, my lord.
Thank you.
So, my lord, subject to the provisions of subsection 5, any person in whose case the order has been made may be placed under the authority of the Governor General. Again, in the Jean case, it said it must be the Governor General, not somebody who purports to be, as it were, acting as a branch of the executive. And then at subsection 4, subject to the provisions of subsection 3 of this section, any person in whose case a deportation has been made may be detained under the authority of the Governor General. So it's got to be under his authority. So there is an elaborate regime protecting people from detention pending deportation or deportation by other people. And the judge recites Section 40, recites Section 41, recites indeed Section 25 of the Immigration Act. And he comes to the, can I just show you his conclusion, which we say is, it still hasn't been answered. It just simply has not been answered. The judge says, in his judgment at 362 is probably the, so after, well, I could, perhaps if the court would permit me, if one looks at his analysis, page 355, paragraph 21, it is undisputed that A, the applicant was arrested by the immigration authorities on the 18th of September and then detained by them. C, the return. The applicant was never charged with any offence. Again, we can be sure that it would have been said in the return. The applicant was never taken to any court. D, no deportation or detention order was issued against the applicant. The applicant was put on a plane. The reason for his arrest and expulsion was stated. Subject was arrested on a routine status check on Firetrail Road. Subject was asked to produce documents and no documents in possession. Subject was brought to the detention centre for further processing. The name was Jean Charles, place of birth Nassau, Bahamas. Yes, well, we've made the point in our note that there isn't such an offence as not producing documents, and there's no offence of, but he deals with that. He deals with arrest and detention. He says, basically, if he's been arrested with a view to criminal procedures, then the Criminal Procedure Code would apply. And he refers to the Takitoka case. That was a case at paragraph 24 where a Japanese visitor, tourist, was seized and detained for 8 years. I think it was 8 years, and there was no authority for his detention. There was a swinging judgment by the President, President Sawyer. And then you see, if any immigration officer or police officers at 25, page 358, forced to suspect any person other than the citizen has committed an offence under this or any regulations, he may arrest such person without warrant, whereupon the provisions of Section 18 of the Criminal Procedure Code apply. Section 18, a peace officer making an arrest without a warrant, in exercise of any powers conferred, shall without unnecessary delay and not later than 48 hours take or send the person to a magistrate. And so it is clear, therefore, paragraph 26, that if an individual is apprehended by agents of the Immigration Department on suspicion of having committed an offence, which is what they say, that individual cannot be detained for more than 48 hours without being brought before a magistrate. And then he looks at the alternative. Well, is this some form of administrative deportation? And he looks at that under the heading detention, deportation, expulsion. Sections 25 and 41 of the Immigration Act outline the only powers of detention contained in the Immigration Act. It appears that neither power arises in this case. Section 25 addresses the process by which persons who are refused leave to land can be removed from the Bahamas. The applicant in this case was never refused leave to land. He apparently was born in the Bahamas. He therefore could not be arrested and detained under Section 25. Section 41 addresses the process by which a person subject to a deportation order may be removed from the Bahamas. No deportation has been made for the applicant. Therefore, he could not be detained or deported under Section 41. And he sets out Section 40 and makes the point at paragraph 30, page 360, there has been no deportation order nor recommendation for deportation. It has been repeatedly stated in numerous cases in the Bahamas that only a court can determine whether a person's presence is contrary to the provisions of the Immigration Act. In one such case, Takitoka, detention or arrest with a view to without being taken for a court is not permissible. This statement was expressly approved by Sawyer in the Court of Appeal when the Takitoka case was heard. But, my lords and my lady, it's more fundamental than that. Look at his ratio. He sets out what's described as the surrender order. You see that at page 362. Bahamas Immigration Detention Centre surrender order, repatriation, and one sees a list of Haitian nationals or Haitian nationals. Some of them are children because one sees the reference to in the left-hand column to there in the lap. And one sees there Jean Charles, aka Jean-Rony. Well, with great respect, it's pretty easy to work out once you've got the materials that were before the court that it's Jean-Rony, first name, Jean Charles, second name. And then the judge says it is unclear on what basis this document was prepared and executed, as there is no law which I am aware which lawfully allows the Director of Immigration to authorise the removal, surrender, deportation or expulsion. We respectfully submit absolutely correct. The Minister has to do it, and there's ample authority on it. Article 25 of the Constitution grants persons in the Bahamas an immunity from expulsion unless authorised by law. Unlike Article 19.4, there is no special remedy or redress indicated for breach of Article 25. I find that the applicant has been deprived of his personal liberty, unlawfully arrested and detained, falsely imprisoned in breach of the rights. I also find the applicant has been unlawfully expelled from the Bahamas. And then he makes various declarations, which, and then the only point made by the respondents, who had been fully on notice of this for 3 weeks, was there may be some other remedy, or there is some other remedy, therefore apply the proviso to Article 28.2, which says if there's some adequate remedy, the court can decline jurisdiction. And he's dealt with that. He deals with that. Article 28 confers a very right to redress constitution, where no remedy is specified, must be able to craft an effective remedy. But if one looks back, he's dealt with that. He's dealt with the only point made by the respondents at that hearing, at paragraphs 16 to 17, at page 349 to 350, where he cites at page 350 in relation to Article 28.2, provided that the Supreme Court shall not exercise its powers if it is satisfied that adequate means of redress exist, and he makes his finding that adequate means of redress do not exist, and he makes that finding at paragraph 18, page 353. I find the applicant's application for redress, having been rendered nugatory or otiose under the habeas corpus procedure for reasons ruled on earlier, can only be realised if the constitutional redress sought is allowed to be deliberated on, as the applicant is claiming arbitrary use of state power meted out against him and multiple breaches of his constitutional right. My Lord, we really do respectfully submit that that is unimpeachable reasoning. And what do we have against that? Well, it's quite true if we go back to paragraph 5 that he says, I can't be absolutely convinced who he is, at page 340, although we respectfully submit one and the same as Jean Charles. Well, he obviously is. But he then says, there's been much publicity in the printed press. In other words, the person's sister's been saying he's detained on his 35th birthday. I'm outside Carmichael Detention Centre, let him out. No question of people not having notice of it. And then there's been much publicity in the printed press and social media, while ordinary that plays no part. I am constrained, in the absence of definitive evidence either way, to hear the matter and make findings and conclusions based upon the law with regard to facts. Now, he clearly finds, on the basis of all the evidence, that on the balance of the probabilities, he is the person, because he makes the findings at paragraph 21. And what is a judge to do faced with, it is likely, perhaps very likely, that someone born in the Bahamas has been subjected to appalling treatment and is now in Haiti where his fate is uncertain. Is he supposed to say, well, until the government admit that he's the same person, my hands are tied and I'll do nothing? We respectfully submit no.
That applies to grant interim relief.
My Lord, in other words, to say bring him back, but, well, I think he probably, it'd be quite difficult to say bring him back, but that's only provisional, because once he's back, he's back. But I suppose, my Lord, it's possible. But, my Lord, what we would respectfully submit is the judge. Sorry. Yes, my lord. It's drawn to my attention that in the Court of Appeal, it was said that the appellant's submissions, that's to say the government submissions, had proceeded on the basis it was the same individual. At the trial.
Sorry, it was...
The case that was put by the government before the judge was it is the same person. In other words, they were saying that the person had... And Justice of Appeal Barnett says...
Which paragraph are you referring to?
But this is... Yeah. It's EB 1167. 1167. EB 1167. I mean, there are countless references of a similar nature. Yes. I've got it. Yes, it's okay. I've got it flagged. 1167 at lines 21 to 23. Justice of Appeal Isaacs. The appellant accepted that the individual deported was the person being sought. Submission at page 150 said so. That's Justice of Appeal Isaacs. My Lord, we do respectfully submit that there really was, can I put it this way, there was no reasonable basis to doubt that a person whose first name was Jean-Rony, second name Jean Charles, had been detained, had been deported. Indeed, that was their case. You can't have habeas because he, i.e. Jean-Rony, Jean Charles, has been deported.
But was it accepted by the government, assuming that it was the same person, was it accepted by the government that that would have been a breach of his constitutional rights?
No, my lady. They just didn't accept. They didn't deal with the point. I mean, no. Their only point.
But isn't that a point that really needed to be dealt with before the judge came to all those conclusions that he did in his judgment?
Well, my lady, my respectful submission would be that if the government is dead batting and taking procedural points, the judge is perfectly entitled, as I'm sure your ladyship would in similar circumstances, to say, well, all you've said to me is if he's got a remedy, it's in false imprisonment. You've put in a return which refers simply to an order from an immigration official, immigration director. On the face of it, that is not an authority to expel. You have provided no authority for his detention. You've not cited any section, any order, any finding of the court, any finding of the minister, which would justify. In the absence of that...
Did that exchange that you've posited, did that take place at the hearing?
Well, my lady, the argument was put by my learned friend, Mr. Frederick Smith, because he was citing, as the judge records, section 41, section 4. But, my lady, I will check that, my lady, but so far as I know, the point taken by the government is the point that he records at paragraphs 16 to 18 of the judgment. So, that my lady, when the respondent objected to the applicant seeking constitutional relief and invited the court to decline jurisdiction, and they're basically saying sue for false imprisonment. Paragraph 17 at page 350. In the unusual circumstance of this case, I do not see how such a course could be described as adequate means of redress. And then...
paragraph 17.
17, my lord, page 350, my lord. So that's the allegation. And then at paragraph 18, I find that the applicant's application for redress, having been rendered nugatory or otiose, can only be if sort is allowed to be deliberated on. And so then he cites the evidence, my lady, of Clotilde. He cites the arrest and detention, page 356. He cites the only authorities for deportation or expulsion from page 359 onwards. He says, well, this is the document that they've produced to justify what's happened, and he looks at page 362, at the surrender order, and then he says there's no authority for that. Now, my lords, my lady.
Well, if you look at the page 372.
Yes.
Paragraphs 5, 6 and 7.
Yes.
The government seems to be saying that the judge was actually wrong to find that there'd been a constitutional breach, and he looked at certain provisions of the Constitution and sections of the Immigration Act, but he misdirected himself in law in the ways that are described there.
My lord,
now, isn't the point against you that they were entitled to some time to marshal their arguments to the effect that actually there hadn't been a breach of his constitutional rights, and that the judge came to the wrong conclusion in that?
Well, my lady, all I can say is this. We're now 4 years on, and they have pointed to absolutely nothing to authorise his detention. You would have thought that they would have said, and the thing you can rely on is X, Y, and Z, but they never have. Here is an order. This is the justification for it. Moreover, when they put in their submissions to the Court of Appeal, the only thing they add, the judge deals with Section 25, he deals with Section 41. The only thing that the only powers, the only thing they add is Section 19, and we've analysed that in our note. Section 19 depends, and that's EB 36668 to 6669. That's their argument before the Court of Appeal. It's
which page again?
so, my lord, 668 to 669. So so, my lady, this is really the point that my lady highlighted. That's ground 6. Wrong to find sections. Learned Judge, Mr. Oak. Wrong to find. Well, what do they give us? They give us Section 19, 25 and 26, Section 40. So, and we say that on examination, either by the Court of Appeal or by this court, that they have identified nothing. They haven't. One would expect them to say, you need a ministerial order, and here's a ministerial order. Or you need an order under Section 25, and here is an order under Section 25. Or you can do it under Section 19 if a person has been convicted and sentenced. And he has been convicted and sentenced. No, I'm saying you expect them to say that. If they had a case, sorry, Fred. Sorry. Once we start arguing amongst ourselves, it's the end. My lord, one would expect them to say, if they're really going to rely on Section 19, which depends on being convicted or sentenced, well, he was convicted and sentenced. Here's the memorandum. And just for the court to be defeated repeatedly by the maybe some justification, but we won't tell you what it is, for 4 years, is in our respectful submission, it is delay of justice defeating justice. It is in our respectful submission a state which must have a duty of, under Huddleston, of honesty and full cards on the table, just playing with a dead bat, saying there might be some justification. Where is it? And they knew the idea that, I mean, after all, in the habeas jurisdiction, even under the 1679 Act habeas, they often looked behind the return. We put in sharp on habeas corpus, and actually in rather interesting cases where people were press ganged, where people would put in affidavits. So this idea that, oh, it's all because the 1816 Act doesn't apply in Bahamas, therefore you can't ask any questions. They knew that they might have to answer some questions, and that's why they put in a full return. And on the Ramatullah jurisdiction, which my learned friend Mr. Frederick Smith was relying on in part, the court in habeas could have ordered, you bring him back from Haiti, you've got a treaty with Haiti, you bring him back. But at least it's arguable. But all I'm saying is the idea that they weren't on notice that they had to produce, and they haven't been on notice for the last 4 years of, well, what is it that justifies detention? And I respectfully submit that the board, deductive as is the argument, let's put it off for another hearing, the board can determine on the materials that were before the judge and any materials that there's nothing more there. And if my learned friend wants to say...
They do refer, Mr. Jean-Rony, to Section 26 of the Immigration Act, I think.
Yes.
If the person that they were dealing with was somebody who had arrived in the Bahamas irregularly from Haiti, then applying Section 26,
yes,
and which goes hand in hand with Section 25, he could then be detained and indeed removed on the authority of an immigration officer.
Yes, my lord. Yes, but he'd have to be found in the Bahamas after landing in contravention of this act. And well, my lord, all we respectfully submit is it's no good for them to say 4 years on, well, we might suddenly discover evidence that he has landed in contravention of the act. I mean, if the spirit of habeas corpus lives on even in the Constitution, and I would have thought it must, this is all back to front. They've got to justify what they did to him, and they haven't come up with any justification.
Well, they don't under habeas corpus jurisdiction in the Bahamas, as I understand it.
Well, they don't have the 1816 Act.
No.
But my lord, I submit that even under the 1679 Act, there was in fact, and we put in a reference to Sharp, that you could still ask questions, and you could still rely on affidavit evidence, and you could still question the return. So and certainly once you've got the Habeas Corpus Act infused by the Constitution, then the fact that long before the 1816 Act came in, i.e. in the 1700s, the courts were looking behind the return, suggests that in a Habeas Corpus Act interpreted in the light of the Constitution, you certainly can. But our real point is, they didn't confine themselves. They put in a sworn affidavit, putting in what their grounds were. And that sworn affidavit and the exhibits there too indicate the unlawfulness of the deportation and detention.
So we don't need to go behind it?
No, my lord, we don't need to go behind the return because we say the return provides the evidence if you take it in conjunction with the birth certificate. But my lord, I'm grateful. My lords, can I just see where we are? Fred, give me a break. My lord, my lady, if we look at the SFI, can I just indicate where we are? The court has, therefore, I think if we go to the return at paragraph 25, page 1466, you've seen the return and you've seen the judge's comments on that. And then the constitutional motion was filed, it's true, on the morning, but it's not as if the note that they didn't have notice of the constitutional motion long before the constitutional issues long before that. And at the hearing, this is at paragraph 20.
Notice you rely on Clotilde's affidavit.
Yes, yeah, and Akira Martin exhibiting the emails, my lord.
But that was produced when?
That was produced on the 7th. Yeah, so they had, and the emails were sent to the parties, as it were. But yes, so they had the emails saying that this is unlawful and unconstitutional on the 6th, and they had the Clotilde saying it's unconstitutional, and then on the morning of the hearing, paragraph 29, page 1467, response objected to the appellant seeking constitutional relief only on the basis that the court should not exercise its jurisdiction. There was no application for an adjournment. And we make the point that we said had paragraph 31 that accepting it was the same person as Jean Charles or John Charles.
Where are you reading from?
This is paragraph 31,
Of what?
of the SFI, my lord, page 1467, my lord. I'm so sorry. Does my lord have?
I do.
Yes. Well, we say there was a certain amount of flanneling around about whether Jean-Rony, Jean Charles was the same person, but the judge rightly found on balance he was. And then paragraph 32, the Respondents' Council, that's to say the State's Council, in fact, this person, by whatever name he may be called, whether Jean Charles, Jean-Rony, Jean Charles, is in fact no longer in the custody or control of the Department of Immigration, in fact, outside the jurisdiction. In fact, as the return certainly indicated, that on the 24th of May, Mr. Jean-Rony, Jean Charles, whatever, travelled to the Republic of Haiti. So that's what their lawyers are saying. And then the judge deals with the point at paragraph, we've set it out at paragraph 34, at paragraph 5 of his judgment. And we say he did the right thing, which is to say, well, I've got to do the best I can in the circumstances. And in fact, he was right. He was right that in the end of the day, Jean-Rony, Jean Charles is the person. So, as it were, well, he might have been wrong. He wasn't wrong. He was right. And as to the writ, the judge held the return disclosed that the appellant was not detained by the respondents. So that was the end of the habeas corpus. My Lord, I think I've really gone through the judgment, but can I just highlight it? The preliminary objection is dealt with at paragraphs 16 to 17 and 18. That's at EB 349 to 350. His findings about the undisputed facts are at paragraph 21. That's to say pages 355 to 356. His analysis of the law is at paragraphs 28 to 30. And I think I've taken the court to that. That's to say, it goes through section 25, goes through section 41, and makes the point that they don't apply. He goes through the document attached to the return, what's called the surrender order, and he correctly rules that that surrender order is not an authority for expulsion. And then he reaches his conclusions at paragraphs 33 to 34. And my lords, it's all set out in the SFI from paragraphs 39, and then you can see that he gives his declaration and remedies, paragraph 42. We respectfully submit that the first declaration is uncontroversial given his findings. The further order that immediately issue a travel document was, in our respectful submission, entirely correct, because you've got to put the wrong right. And it will be your remedium, as Lord Scarman said in Riley, about once you've got a constitution, you can't just sit back and say, well, there's nothing we can do. And then the respondents pay the reasonable cost of travel back to be paid forthwith, for that's unexceptionable. Then the issue such status to the applicant was permit him to remain in the Bahamas. That was the order made in the case of Takitoka by the President Mr. Justice Sawyer. It was. Oh, no, it was. Oh, he made it, but then she upheld it. So, yeah, sorry, it was made by Hartman Longley in the case of Takitoka. Sorry. Yeah, the Hartman Longley made. Yes. So now, if my learned friend has a point that that's going too far, well, the board can simply strike out that particular remedy. But the other ones we say simply can't be questioned. And I've given your lordships the grounds on which we say there's precedent for free, and actually, given that he was born in Bahamas on their own case, it was a reasonable thing to do, and it was what was done after an injustice had been done to Mr. Takitoka in that case. He was a Japanese citizen, but he'd been wrongly detained. So then we've got the appeal by the respondents. My lady's alerted us to the fact that there were substantive challenges there, but we say no clear steer as to what their position is. And at paragraph 46, respondents filed an application for a stay of the constitutional relief pending their appeal. The affidavit in support of that application is contained there. Again, they don't at that stage say, oh, there's all been a terrible misunderstanding, here's the order, here's the authority. They're still saying there might be something in the interstices of the Immigration Act, somewhere between section 25, 26 and 19, all of which we've cited, but none of which we've relied on. And then paragraph 48, also on the 3rd of February, the respondents made an emergency ex parte telephone application for a stay of constitutional relief, and then he's brought back, but he's detained immediately, and then his release is ordered by the judge.
And he's been released. He's still released, and he's still present in the Bahamas.
Is he still present in the Bahamas?
Yeah.
And certainly it would be our case that there wouldn't be any lawful basis, given that even if he's not a citizen, he would benefit from the legitimate expectation under the policy that I've...
What is astonishing is, as far as we can understand, no step has been taken by the government in the 4 years to clarify matters. And has Jean-Rony, has he taken steps to get permanent residence?
My learned friend, do you want to? Can quickly.
Good morning. Mr. Jean-Rony has applied for a work permit, and we are still waiting for the government to respond to it, despite reminding them. And we have prepared a citizenship application for him, and we have written to the immigration authorities several times, asking them to produce the documents which would help him to process, because they won't accept the application without all the back documents. And they have failed to respond to us on that as well. So we have been unable to get a work permit in the meantime, and we've been unable to pursue the citizenship application. All of which documents are in the government's possession through the 5 the registration processes that all the sisters went through. You can recall from the evidence that all of Mr. Jean-Rony's documents disappeared in the fire, where then his house burnt down where he was staying. And so that answers your question, my lord, unless there's anything else.
Has the appellant taken any step to prove that he is the brother of Clotilde, for example, by DNA or anything like that, to resolve any identity question?
We haven't.
No. Thank you.
Well, that's the position then. The Court of Appeal, I've moved on to the Court of Appeal judgment. I could just very briefly indicate what they say and why we say it's wrong, if that would assist the court. Again, we've summarised it at paragraphs 58 of the SFI from page 1474, but if I can just take you to the judgments of the Court of Appeal. They're in the bundle at volume 3 of the record, and the judgment of Justice Barnett, Justice Appeal Barnett, starts at page 1372. I think if I can just take you to the key passages. He sets out the history, and then at paragraph 27 on page 1388, he says, there's two issues. Was the trial judge correct to dismiss the writ of habeas corpus? And was the judge correct to grant constitutional relief? And then there's no dispute, obviously, about the dismissal of the writ of habeas corpus, but he makes some remarks about the affidavit of Clotilde Charles at paragraph 30, page 1389. Why didn't she explain why he couldn't make it on his behalf? The judge considered all that and regarded those defects as ones that could be cured or that didn't. So it's not as if the judge didn't consider those points, because they were made by the state at the hearing. So our point in answer to that is those defects were considered by the judge, and he regarded them as not sufficiently material to debar reliance. And we respectfully submit he was entirely correct. The court will know that frequently in habeas corpus, a solicitor signs something on behalf of the person that says, I haven't been able to get hold of him, but this is the best I can do. He's detained, and the judge will hear it in order, make some interim order straight away.
But paragraph 31 is perhaps a bit surprising, because it seems to suggest that it raises the spectre of whether or not he was unable to give the affidavit because he was no longer restrained. But at the time Clotilde issued the affidavit on the 27th of November, she believed that he was still detained. Yes, exactly. And because the government had not informed her or the wider family that he'd been deported 3 days before, or repatriated 3 days before.
Yes. Well, my Lord, we respectfully submit that these points are all, I don't want to be unduly disrespectful of procedural points, but they are fairly footling pedantry. The fact is, somebody is being detained, they're being detained unlawfully. His sister, who again the judge knows because she's on the television all the time saying, "Where's my brother?" is saying, "I'm doing the best I can." And she so in her affidavit it goes on and on that she was authorised to make it on her behalf of paragraph 38, page 1390, and then he says the habeas corpus must come to an end. And then there's the stuff about Kira Martin's affidavit, which we say is, I mean, she exhibits real-time emails, which are real evidence. These points were drawn to the attention of the authorities, and they did nothing. That's a fact. And then we get on to the ruling, paragraph 48. In this case, the appellant were no longer detaining the applicant. There was nothing before the court by which it could have been concluded that the power to require it to be brought back under its control. Well, that's just not true. It was clear that he had been sent from the country, and in the Ramatullah doctrine, there might well have been something. But then the key passage is from, should the court have granted constitutional relief, from page 1393 onwards. Firstly, at paragraph 53, habeas corpus having been brought to an end, the court ought not to have considered any further application of that action. But there is no such doctrine. Before the judge, throughout the hearing on that day, was a habeas and a constitutional, and he was entitled, and the constitutional recited that they were going to rely on the evidence of the return and of Clotilde, so it was all before the court. Secondly, at paragraph 55, there was some question about who the person was. Well, we say the judge dealt with that as best he could, and rightly said, effectively, one has to read him as saying, on the balance of probabilities, I think that Jean-Rony, Jean Charles, is the person I should refer to, and he is the person who the other side, as it were, or the respondents accept, was deported. And they have tried to explain why he was deported by producing the return and the surrender order. And then it says, thirdly, it was obviously unfair to the respondents to have to deal with an application of constitutional review. We say absolutely not. They had 3 weeks of notice that it was being said that it was unlawful and unconstitutional. And if they can't, in respect of someone born in the Bahamas, come up with an answer, then respect the court shouldn't wait and say, well, we'll give you time to see if you can think up something. That would be contrary to the whole spirit of the law, which is that there's a presumption of illegality in detention. And if one goes on to Justice of Appeal Isaacs, we have his judgment from paragraph 63 onwards. He finds on grounds 2 and 4, which he sets out at paragraph 66, rather than consider and determine it without affording a proper opportunity, in any event, the affidavit and the judge made in determined constitutional in the absence of any affidavit evidence. Well, there was affidavit evidence. It was the affidavit of Coteau and the return of the government itself. So he says, so his findings, he refers to him as Jean-Rony at paragraph 72. And if I can just summarise the findings of Justice Appeal Isaacs, you see at page 8, at paragraph 81, he says, paragraph 81, 1405, once the judge was satisfied the return disclosed the appellant was not in the obliged to decide formally the writ not issued. We don't quarrel that for the moment. Paragraph 85, Mr. Smith is invited to find dismissal of the writ somehow invalid, but that's not pursued. But last sentence, once the judge determines the writ should not issue, whether he dismisses it outright or not, the applicant is in then cannot be resurrected by some application of contempt. This again is allowing, with our respectful submission, procedure to obscure substance. The complaint throughout was constant. He is being unlawfully detained, and if he was expelled, it was unlawful. The complaint did not change. And if habeas and constitutional remedies can overlap, and we've cited numerous authorities that they can, then there is a public law issue for determination in both proceedings. And paragraph 88, to my mind, information provided in the return about another person ostensibly, well, it wasn't, it was the same person on any sensible view, was gratuitous surplusage. That's an extraordinary statement. This is the state being asked by a judge to justify detention. And he's saying that their justification of detention is gratuitous surplusage. Once you've said that we've no longer got him. One, that overlooks the Ramatullah jurisdiction, but two, on what basis could the responsible government's return be disregarded? They are purporting to justify what's gone on. As I respectfully submitted, if they really had been logical in the position, there's nothing to argue about because he's not in detention, they wouldn't have set out in detail the affidavit and the return. And then at 91, we say a misdirection of law in the absence of certainty as to the identity of the applicant, there could be no finding of a constitutional breach. You don't require certainty. Very often in law you don't have it. A balance of probabilities will do, and I respectfully submit that it is clear now, and actually it was before the Court of Appeal, beyond peradventure, that there is a person, Christian named Jean-Rony, surname Jean Charles, like his sister's surname, that she wasn't out there demonstrating outside the centre for someone who was a stranger to her. And the judge rightly took into account both her affidavit and the return. And so we respectfully submit none of those grounds have any justification. Yes, my learned friend, Ms. Frederick Smith, has drawn to my attention a very short summary of the respondent's position before the Court of Appeal, that they were, i.e. that he was one and the same. I think we've set it out in the case too at some detail, my lord. But
This is additional.
okay, there are additional points. Can I just give them to you? Mr. Klein, authority representing the state, said, this is at page 935, sorry, 934 line 18 to page 935. Should I just read out? He was removed to Haiti and released. The state no longer has any control over him. And then he says, the judge, page 937, I quote, the judge, having said it is dismissed, is really tantamount to saying my jurisdiction has come to an end because the person is no longer in detention or custody, therefore it fell away. And then further, as to the person who was detained, deported and returned, the government accepted and conceded that the person who was in the detention centre and was removed has been returned. That's page 971. 971. Can you give me the line?
Well, there's no dispute. I mean, the respondent accepts that the person who was removed was returned. Yeah. I mean, that isn't the dispute. The astonishing point is that 4 years on, no one seems to have, on the government side, seems to have clarified what the position is.
Yes. Well, my lord, we say this is a real Huddleston case. A government cannot sit on its hands and say, you prove your case, we'll take technical points about your affidavits and all that. Once there's a clear prima facie case of unlawful detention, they've got to come clean and say what they know. And they do know, because they've got all the records. They know the position. And we respectfully submit it is actually undermines the rule of law to have a situation where they're still taking technical points about whether it's obvious in our respectful submission that Jean-Rony, first name, Jean Charles, second name, same as his sister, the person the sister was interested in pursuing, whose birth certificate is provided, is the person who was detained, that's why his sister was kicking up a fuss about it, is the person who was expelled, is the person who Mr. Frederick Smith went to Haiti to find and bring back. And to have this, the Court of Appeal dancing on the point of a needle about how far it had been shown beyond peradventure, and therefore the judge shouldn't do it, is undermining all the noble work of the judge, doing exactly what, in our respectful submission, the rule of law required him to do, which is to say, I've got to deal with this situation, I've got to do the best. It was a reserved judgment too. If in the intervening weeks they had anything dumbfounding, nobody would have stopped them if they had suddenly said, we want to put it in. They just sat around hoping that they would win, hoping that their Article 28(2) point would succeed, and avoiding any engagement with the court on the facts or any fair disclosure in accordance with Huddleston principles. And I respectfully submit that the court in those circumstances should uphold the judge's findings. Yes, page 971, it's at line 8. What we are conceding, my lords, is the person who was in the detention centre and who was removed has been returned. But I think my Lord Hodge was what you were saying was, well, could he be someone else? But
no, what I was saying is what I said at the outset, that what the government had conceded was the person removed from the detention centre was returned to the detention centre.
Yes.
But you say that faced with the documentation which they have, it is rather singular that they haven't, as you would put it, come clean.
My lord. I couldn't put it better, man. It's in our respectful submission, it's simple as that. Now, my lords, we've dealt with the various points. Can I just deal with them in turn? But that's not the point. Sorry. Yes. No, okay, yes, I've got, okay. Well, my lord, Okay, can I just deal with it? It was their case that the appellant was the person, that the appellant, that's to say Jean-Rony, Jean Charles, was the person who was deported, i.e. that the person who is the appellant was the person who was deported. And we've set out that, I'm very grateful to my lawyer, we've set that out in our written case, paragraph 63, page 1503, they stated the subject, Jean-Rony, so page 1503, had been expelled. So the subject, i.e. the person who's before the court. And then 67, page 1504, yes, the applicant is currently in Haiti. Yes, that's in their submissions. Expressly stated that the applicant was currently in Haiti. In other words, they're saying the person who's bringing this proceedings is the person who was deported, is the person in Haiti. And the person who was bringing the proceedings was Jean-Rony, Jean Charles. And at 70 Roman 1, explained the return showed that no matter what his true name was, the appellant had been taken to Haiti and was no longer within the Bahamas, as can be seen from the following submissions. We attempt to show that, in fact, this person, by whatever name, is in fact no longer in custody. So there is a person called Jean-Rony, Jean Charles, who was detained in September and then removed and then brought back. And so what do we have? We have the fact that he is reported, he gave the right name, he is called Jean Charles. He's reported to have said that his birth date was in 1982 rather than 1985. Now, that's simply what they record. For what it's worth, our instructions are that he didn't say that, but that's what they record. But they could have checked. His sister was begging them and applying them with documentation. And where did they get, when it's in that manifest, Jean Charles, aka Jean-Rony, where did they get it from, if not from the sister? They would have just said, so they knew that he was Jean-Rony, Jean Charles all along, we say. So, my lords, the grounds on which we've summarised very quickly is that, one, there's no doubt that you can plead a constitutional breach in habeas and rely on evidence in habeas for a constitutional breach. And we've set that out in some detail in D1 from pages 1487 onwards. As my Lord said, my Lord Reader said, that there really isn't much dispute about that. But you wouldn't have guessed as much from the way the court said once the habeas is gone, you can't revive it and all that. That's, again, contrary to the whole spirit of constitutional relief, that you can raise it just by, you can raise it even orally, and there is authority which we've cited to that. Can I just give you that one reference? It's where, at paragraph 31, at page 1495, we refer to Jaru, and then we refer to Kenrick Seaford at 32.2, and I'm so sorry. There's a judgment from Justice Sawyer where she basically says you can raise it orally. That's right. It's at page 1493, 24.1, Mot C. An oral motion in the course of the hearing was enough. Well, this was a written motion, long heralded, and in fact substantially overlapping. And this kind of barren proceduralism was exactly the point that was taken in the case of Bow against the appellants and overruled by Lord Bingham, where they were saying you have to start again with a constitutional motion. He said, no, you can raise the constitutionality of the mandatory death penalty in the course of a criminal appeal. And that Bow is referred to at paragraph 44. The second point, D2, judge was entitled to rely on the evidence of the return and the affidavit of Clotilde Jean-Charles in reaching his conclusion. My Lord, we've really set that out there, but there's nothing wrong with relying on the return to a writ. It's done in Nidika, that's at paragraph 50. As to Clotilde's affidavit, we analyse that at paragraph 51. We make the point that any defects were said by the judge to be cured, paragraph 52, page 1501. The judge addressed the defects and said they were cured. And much of what Clotilde said was actually first-hand evidence. I have been providing them with these documents. I've been asking. They have not been responding. They have told me they've lost my son's documents. That's all admissible on any view. But in any event, habeas corpus would die if you couldn't sometimes refer to hearsay. And there is good authority in cases such as B that you can rely on hearsay in human rights contexts. The identity, so that's the second point. The third point, the identity issue we dealt with at D3, and we say, in the end, it's a non-issue. And we say, with great respect, at paragraph 60, page 1502, that Justice Appeal was wrong to hold that it needed to be sure or certain, sufficient for the judge to decide on balance of probabilities, and he did. The respondents accepted and argued that the appellant was the person whose detention and expulsion was described in the return. And we've dealt with that. There are numerous citations where they're saying he is the same person, and they're saying the appellant, i.e. the guy who is appealing in this court. He was actually there, wasn't he, at the final? He was there, yeah, he was there. He was there, sitting in court. I mean, it defies belief that they carry on taking these points about identity. And as my Lord Hodge has pointed out, the government have got all the resources in the world to establish, if he's not, that he's a fake, and if he is, that he's the person. And they have come up with nothing other than, let's look at the position where the poor judge is grappling with it in 19th of December. He should have done better. No, he did the best he could. He made a finding on the balance of probabilities, and in our respectful submission, not to uphold it would be it'd be contrary to the law, because he was applying perfectly legitimate legal principles. And then paragraph 75, at page 1506, taking the judgment as a whole, the judge did decide that you refer to, and not someone else, and we've given you the various citations. And the further point, when he's there sitting in court before the Court of Appeal, paragraph 86, by the time the matter came before the Court of Appeal, the factual position had developed, and even if there had been some uncertainty at first, it had been dispelled. The emergency travel document had been issued. He was located by members of his legal team, etc., etc. We've set it out. So then finally we have the fair hearing point, and our points that should have heard more fully. We do rely on the fact, one, they didn't apply for an adjournment. They simply took the proviso to Article 28(2) point. And at paragraph 97, page 1512, we make the point that the respondents didn't apply for adjournment, didn't seek to deploy further evidence. More importantly, they've suffered no injustice, particularly in circumstances where the egregious conduct to which the appellant, in circumstances where the identity issues are red herring, the judge's conclusions regarding the conduct were we say utterly justified. And we make the point, if you don't apply for an adjournment, then that is a major point against saying the judge of his own motion should be saying, would you like, well, I'm going to give you an adjournment whether you like it or not. And we make that point from paragraph 98 onwards. And I think it's right to say that Mr. Francis accepted that there was no application for an adjournment, or at least he couldn't recall that there was. Yes, as you can see that at paragraph 100.3 at page 1516. I am not aware that a specific request was made. I cannot say. And one has then, yes, paragraph 100.3. Mr. Klein, that there was a preliminary objection, my lord. Did they request it, i.e. the adjournment? I am not aware that a specific request was made. I cannot say. And he said, and then we see, and then the procedural error, and then Justice of Appeal Barnett reasonably says, and you say that was made whether or not an application for adjournment was made. Yes, my lord. I think that my brother, Justice Isaacs, is saying is that in the absence of a specific application for an adjournment, can you fault the judge for proceeding to hear it? So we make that point. Well, okay, I'm just getting there. And then if we go on to paragraph 102, the respondents had, yes, this is an important point with my own friend, right? They had an affidavit, but they didn't deploy it.
Well, can we infer anything from that? We have no idea what was in it.
Well, my lord, in other words, they're obviously holding something back. And they don't ask for an adjournment. They don't say, we've got crucial evidence which would make a difference to the judge, and please give us, I mean, it would have been really easy for them to say, look, we're not trying to hold things up. We recognise that it's important for a swift decision to be made, but we have got some things which we'd like to draw to the attention of the court. Give us a fortnight. And we'll... Yeah, yes. Yeah,
and was at the hearing on the 19th of December?
Yes, that's my lady, yes. So that's 19th of December. Appellant filed this morning, had an underfilled affidavit which he intends to rely on. He doesn't. So, well, I would submit that what it shows is they had something which they decided that they weren't going to make use of, so that they...
Because I understand what they say is that they thought the judge would deal with their preliminary objection and go no further.
Well, my lord, there wasn't anything that he said that indicated that, and then he reserves judgment for a month, for nearly a month. So he wasn't. I don't think he was reserving it just for the 28. I mean, it wouldn't be a reasonable inference that he was reserving it for the 28-2 proviso.
What can they do? They can't say, you seem to be taking a long time. Are you about to decide things that you didn't hear any submissions on? That's not the way they can approach the court. What are they supposed to do when the weeks go by and there's no judgment coming out?
Well, my lady, what I would respectfully submit is it was perfectly open to them, if they had something which was relevant, to say to the court, either at the hearing, look, there are matters we'd like to draw to the attention of the court, or subsequently. I mean, indeed yes, I think it's right that that's on the trial day, on the 9th. Yes, at the trial hearing, and we can see it. My learned friend did actually say that they could have 21 days to put in evidence. My learned friend, Ms. Frederick Smith, made that suggestion, and they didn't take advantage of that. I mean, because we respectfully, can you just give me the EE bundle reference? Is that EE? It's page 203 to 204 of the. So he actually made that suggestion at in the bundle at page 203 to 204. Sorry. Yes, we say that at the top of page 204, giving them a 20 will allow them time to come back to the court to seek to persuade the court on the facts. Well, yeah, so that offer was made. It wasn't pressed by the respondents, and we say, and then, my lord, on the point, well, were they taken by surprise, as it were, by the course that things took? We've tried to deal with that at paragraph 104, where an applicant seeks an order for a new trial on the basis that he was taken by surprise and was unable properly to meet the point, there is authority that he must show that he did not choose in the circumstances to proceed and see what the court would decide, i.e. take your chances. But moreover, and perhaps more important, that you must show that you had evidence which would have made a difference, or arguments which would have made a difference. And we say that we've given the citation from Order 59, and your Lordships and my Lady will see the second bold passage. As to 3, if the applicant's case is that he had evidence available to meet the new case, his affidavit must contain a full statement as to the witnesses he proposes to call and their evidence, and show that likelihood he may prove the former decision to be erroneous. Now, I accept that's a different context, but we do respectfully submit that that's a basic principle of justice, that that if they really are saying we were taken by surprise by the turn of events, and there were points we wished to make, and there was evidence that we wished to adduce, they should identify that. And certainly they should have identified in the Court of Appeal, and they should identify it before the board. Yes. 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 I mean, the Huddleston principle I've referred to, the duty of the state to make full and frank disclosure, is actually referred to by Ms. Justice of Appeal Isaacs at page 1140, lines 19 to 23. Hasten to say there is an obligation on the state to make full and frank disclosure on a habeas corpus application. But we would say the same in relation to a constitutional matter. So, my lords, my lady, we say that the judge's findings were fully justified, and we further say that they have actually identified no substantive unfairness. And then if we go to D5 at page 50, EB 1522, my lord and my lady, we rely on the appendix. Did the court receive a small additional?
We got a 15-page bundle this morning which contains the writ of summons.
Oh, that was. I think my learned friend put it in on the other side.
Right. We've received a whole bundle, a whole lot of bundles fairly recently. Which one is it?
It's called a summary of key legal
Yes,
provisions.
we've got that. Yes. Yep.
Yes, that's it. That sets out, and it's dealt with in detail in the appendix, where we say these are the various ways in which you can be legitimately deported. These are the orders that can be made. None of them were made. These are the various grounds on which you can be legitimately detained. None of them apply. And so that's our submissions, which are set out more fully in the appendix and then summarised in the summary of key legal provisions. My lords, my lady, I think I've made my submissions as to the remedies. We say that we acknowledge that the direction to give him a work permit, if I can summarise it bluntly in that way, is in a slightly different category, although there is precedent for it. We say all the other remedies were entirely justified. And we do invite the court to uphold the judge's order.
There's going to be a hearing anyways, though.
Because of the...
Well, you've issued a...
Well, yes, my lord, that writ is without prejudice to right. These. It says at paragraph 8 that...
There's going to be a damages hearing, presumably, or not?
Yes. I mean,
you're right.
Yes, I think it was because the time limit was going to run out otherwise that it had to be issued.
Which paragraph were you referring to us in your case?
My lord, it's in the document that my lord will referred to, which was put in by the other side, and which indicates that a writ has been issued, my lord. It's called Supplemental Bundle of Documents. And
We have it in a number of versions.
oh, right.
One of which is described as a supplemental bundle of authorities, volume 2.
Well, I have it in the supplemental bundle of documents, but can I just give you the reference at paragraph 8, my lord? Such aspect or portion of the claim which relates to the claims for relief sought, granted by the Supreme Court judgment set aside by the Court of Appeal, are made without prejudice to the plaintiff's right to pursue the Privy Council appeal.
Page 6.
Yes, page 6, my lord.
But you also say that if you succeed on the appeal, you'll remove duplication, but otherwise proceed on the remaining causes of action. So there's going to be a
Yes.
hearing anyway.
Yes, my lord, yes. Yes, I accept that one. There will be a hearing. But we respectfully submit that the judge reached the right conclusions. If the board were against us on the natural justice point, then we'd ask that the case be remitted back to the Supreme Court rather than otherwise, because of course one could always amend to add additional things, and one could. But we say that in principle, it was a perfectly proper thing to have a constitutional motion relying on those documents. Now, as my Lord Hodges pointed out, there might be further evidence that could be deployed, but if we went back, as it were, to the Supreme Court, if it went back to the Supreme Court and we carried on without the judgment, but still relying on Clotilde's affidavit and the return, it might, well, we understand, or they haven't identified it, that my learned friend would be putting in something, arguments at least. But we could, of course, then put in further evidence. And so our first invitation to the court is to uphold the judge's judgment as entirely correct and that it should stand. And our second invitation is if the court concludes that there was unfairness, then our request would be that the matter be remitted back to the Supreme Court to, as it were, continue the hearing of the constitutional motion. And obviously, the judge would then give directions as to what the appellant could further add and what the respondent should disclose and what the respondent should.
But how's that going to fit with your writ of summons, which you intend to pursue anyway?
Well, my lord, no, we don't.
You're clearing much wider relief than just.
Yes. Well, my lord, one simple solution to that would simply be that the existing claim for constitutional relief could be amended to add in the additional, or consolidated. In other words, what we say that in principle this was a perfectly proper application. There was nothing to stop it being made, and it has been wrongly, as it were, truncated by the Court of Appeal. If it's remitted back, one could either amend to add in the points that were made in this writ to save to deal with the time limit, or they could be consolidated, as my learned friend has said. But we do respectfully submit that the order should stand. And I suppose.
But that wouldn't then dispose of this new writ of summons, because there are additional.
No, my lady, I do accept that. I do accept that.
But your primary position is that you seek the restoration of the judge's order.
Yes. We say restore the judge's order if you think that the particular thing about working. So restore the judge's order. There is this additional thing that can't be as it is. We're entitled to as well. And we've indicated that to the extent that the judge has already ruled some of its res judicata, we wouldn't pursue that. But My Lords, my Lady, we say that in principle and on the evidence before him, the judge reached entirely right decision and was under no duty to adjourn, there being no application to adjourn, and that his findings were right and should stand. Well, I think I've now eaten up the time anyway, my Lord.
I think you are running out of time, yes.
Those are my responses.
Thank you very much, Ms Fitzgerald. Mr Poole.
My Lords, my Lady, there are two main issues in this appeal. First, having dismissed the appellant's habeas corpus application, ought the judge to have gone on and determined the constitutional relief application in the way that he did? And then the second related point, was the respondent afforded a fair hearing when it came to that application for constitutional relief? And our overarching submission is that the Court of Appeal was plainly right to hold that the judge fell into error when dealing with the application of constitutional relief in the way that he did, and that resulted in unfairness and prejudice to the respondent. Now, the main reason we say the judge fell into error is that the final relief that was claimed in the application for constitutional relief, we say, could not be fairly granted without a factual inquiry and determination of, at the very least, the appellant's identity. And there's two aspects of identity in this case. The first is the issue as to whether the appellant is the person whose treatment is described in the return to the writ, i.e. the person that was stopped in question on the 18th of September 2017. And then there's a second issue as to identity, is what is the appellant's correct name, date of birth, and status in the Bahamas? Both of those issues, we say, needed determination before the judge could fairly grant the relief that he did. Before addressing my learned friend's four main arguments on appeal, what I propose to do is make some points on the evidence. And I'll try not to repeat anything the learned friend has said, but when I say the evidence, as was made clear by the judge at first instance, the evidence that he relied on for the constitutional relief application was Miss John Charles's affidavit and the return to the writ. So dealing first with the affidavit, the board has got that at pages 20 to 22. The affidavit starts by saying that Miss John Charles is the sister of Jean-Rony John Charles. We know from her passport, which, just for the board's note, is at page 433, that she was born on the 8th of November 1981. So that puts her 13 months older than the date of birth that's given for Jean-Rony John Charles on the birth certificate. And that's the birth certificate exhibited to this affidavit, page 24, which states that Jean-Rony John Charles was born in Nassau on the 5th of December 1982. And just looking at that birth certificate at page 24, the mother and father's places of birth are not stated, but we are told from other sources that neither is a Bahamian citizen. Just for the board's note, there's an email from Mr. Smith to the Department of Immigration. I think you were taken to it's page 30, email of the 6th of December, that refers specifically to Jean-Rony John Charles's mother as being from Haiti. And there's a later interview that Mr. Smith gives to the Tribune, which is page 496, where he makes the point that this case, he says, has paved the way for people born in the Bahamas to non-nationals to seek protection from unlawful expulsion. And so it follows, and there was discussion the board had with my learned friend, it's section 7.1 of the Constitution. Despite, on the face of the birth certificate, being born in the Bahamas, Jean-Rony John Charles is not a Bahamian citizen. And that's implicit in what is said in the affidavit. Paragraph 5 of the affidavit, page 20. Miss John Charles says that Jean-Rony John Charles is entitled to Bahamian citizenship. Now, it was common ground before the judge and the Court of Appeal that Jean-Rony John Charles had not applied for citizenship in the 12-month window that is permitted after his 18th birthday, and he had not made an out-of-time application. And that's what prompted Mr. Smith, and you see this at 4:07 in the electronic bundle, in an email on the 1st of February to describe Jean-Rony John Charles as a citizen in waiting. And there was some discussion in the Court of Appeal about Mr. Smith's use of that phrase, and just want to take the board to that. It's
could you give me the page again, please? 400 and...
The page for the email is 4:07, my lord.
Ah, yes, thank you.
Now, citizen in waiting, it's not a term of art. I think it's a term that Mr. Smith has coined. And as I say, there was discussion of this in the Court of Appeal. And if I could just ask the board to turn to page 1244, line 13. Mr. Smith is asked to explain Jean-Rony John Charles' status. He refers again to him as a citizen in waiting. You see that at 1245, line 24 to 25. Mr. Smith, though, later, at 1320, line 21, concedes that this is not an appropriate description, and Mr. Smith submits that Jean-Rony John Charles' status should not be determined without full argument and evidence from both sides. He then confirms 1321, line 16 onwards, that Jean-Rony John Charles has not made an application for citizenship and therefore cannot be properly described as a citizen in waiting, as that would, he says, only apply to those. Sorry, my lady, 1321, line 16, and it's quite a lengthy exchange. He says that would only really apply to those under the age of 18 or those 18 to 19 who had made an application. Just whilst on the affidavit and on this question of citizenship, when considering what evidence the respondents might have wanted to deploy in response to the constitutional relief application, it is relevant in my submission to note that we are told, again, it's not in affidavits but in emails, that Jean-Rony John Charles has 5 siblings. I think Mr. Fitzgerald took your lordships, my lady, to it. It's an email, again, 6th of December, it's page 31. And in that email, it is said by Mr. Smith that they are all Bahamian citizens. Now, there's a footnote in our written case, it's first footnote at page 1540, where it's noted that Jean-Rony John Charles has 3 male siblings, one of whom was born on the 2nd of January 1985. Now, assuming John... Sorry, my lord. 1540 is the reference to footnote 1 in our case, and this was a point that was made in the respondent's skeleton argument for the Court of Appeal. Now, assuming Jean-Rony John Charles was the person stopped and detained on the 18th of September 2017, the fact that he has male siblings who are, we're told, Bahamian citizens might, and I say might because this hasn't been explored in evidence, explain why a different date of birth was given. Just as my learned friend says on instructions, his instructions are that was a simple mistake. We don't know, because that discrepancy has never been addressed, as in my submission it
so would you say it was his brother who was picked up?
My lady, no, it might well explain why the person that was picked up gave an incorrect date of birth. In other words, gave a date of birth that he believed may be a date of birth, one of his male siblings, who is a Bahamian citizen, we are told. But as I say, this is, I readily accept...
I thought he said his date of birth was December.
My lady, it's not, I don't for a moment suggest he said 2nd of January 1985. It is the year that is of interest. In other words, it still would be an error. It still would be not one of his siblings' date of births, but it might explain it. But I readily accept this is speculation, because none of this has been the subject of any inquiry or any challenge to the evidence given by Miss John Charles. And at the very least, the respondents would have sought to have asked questions about these discrepancies. And when I say these discrepancies, I mean the discrepancies between the information given in the affidavit and the information set out in the return to the writ. Perhaps more importantly, and back onto the affidavit, paragraph 6 of the affidavit, Miss John Charles asserts that Jean-Rony John Charles has never left the Bahamas. Now, this is potentially an important point, because whether or not Jean-Rony John Charles had left the Bahamas is relevant not only to the lawfulness of his arrest and removal, but the final relief that was sought and granted by the judge in my submission. As a non-citizen, if Johnny Ron Charles had left the Bahamas, depending on how he returned, he could well be committing an offence under Section 26 of the Immigration Act, and that's the section that Lord Reid took Mr. Fitzgerald to. The consequence of that would allow for his arrest under Section 9 as potentially being suspected of committing an offence under Section 26. But Section 26 would also permit removal by order of an immigration officer. And the surrender order in my submission would be such an order given by an immigration officer, because there is no deportation order that the respondent relies on in this case. The surrender order is the order that is at page 362. But again, these are issues that weren't ventilated, weren't explored, and weren't adjudicated upon.
But again, this is speculation, isn't it?
My lord, it is, but it's a bold assertion in Miss John Charles's affidavit. And as the Court of Appeal note, and question, was she in a position to make that assertion, given the respective closeness in their dates of birth? And the point is made. If he had left when she was young,
he was picked up in the road. He wasn't picked up stepping out of a rowing boat on the beach.
He was picked up, looking at the address given, on a road. We don't know, I can't speculate on the circumstances where that precisely was. Landing is either landing from a plane or from a boat. And it wouldn't have to be literally picked up on the tarmac or picked up on the shore for there to be a potential infringement of Section 26. But the point is this: there was evidence before the judge that suggested that Jean-Rony John Charles may well have left the Bahamas, which would have been that evidence. My lord, was if you. Look at page 429. There's a letter from Calendars, the appellant solicitors. It's the 11th of December, 2017, and it states that Jean-Rony John Charles's mother obtained 6 or 7 travel documents from the Ministry of Foreign Affairs in the past. And then over the page 430, it says, given that he has been issued with travel documents in the past. Now, in my submission, there would have been no need for such documents unless Jean-Rony John Charles had left the Bahamas.
Have you raised this point before at any stage?
My lord, these are yes. Is the short answer. It was raised in argument in the Court of Appeal, and has the point was not lost on the Court of Appeal in my submission, and feeds into their determination that there were factual issues that the judge wrongly asserts in his judgment were not in dispute. And that is a serious error in my submission in the first instance judgment. And the judge himself appears to question the weight that he ought to have given this Miss John Charles's evidence on this point. We see that in the transcript. If you,
just before you leave this, yes. Your submission is that these 6 or 7 travel documents wouldn't have been needed were she to have travelled on her own. Is that what it comes to?
These are travel documents on the basis of what's said in that letter. These travel documents that she has obtained for Jean-Rony John Charles.
I see. Pardon.
And it says, given that he, so we assume Jean-Rony John Charles has been issued with travel documents in the past.
Yeah.
You said a moment ago that, or I thought you said, that if he had done something which would allow for his arrest under Section 26, that would permit an order to be made by an immigration officer. But that seems to go against what Mr. Fitzgerald was saying, which is that a deportation order always has to be made by the minister.
A deportation order under Section 40 does, my lady, but an order under Section 25 and 26, as is set out in 25(4) and so it's page 1596. A person to whom leave to land is refused may be detained under the authority of an immigration officer pending the giving of directions, in his case, under paragraph 1. And then one goes to paragraph 1, where leave to land is refused to any person. Section 22, an immigration officer may, subject to subsection 2, give directions for, and then it's the removal. And then section 26 is the provision that states that...
That's the removal in the ship or aircraft in which he arrived in the Bahamas.
Well, yes. And also, I would draw attention to 25(2), which is no directions being given after 2 months. So again, I accept there would have to be inquiry into these facts, and there should have been, or at the very least, the respondent should have been given the opportunity to address these, given that, yes, there are elements of speculation, but where you have a letter from the appellant solicitors referring to travel documents being issued in the past, I say that gives a foundation for more than speculation and to legitimate challenge being made to that part of Miss John Charles's affidavit at paragraph 6.
Directions given under paragraph 1 don't have to be specific to the ship in which the person landed. That's a situation envisaged in 1A. 1B and 1C, I think, are rather wider.
I'll say such ship or aircraft.
It looks as though you have to be able to identify the ship or the aircraft in which the person arrived.
These were substantive points raised on appeal by the respondents in the Court of Appeal that the Court of Appeal did not feel they needed to determine because they determined, the, if you like, the procedural points. These are still live issues that have not been determined and which my learned friend would say, and certainly Mr. Smith would say, are important points that potentially touch on a number of people in a similar position to, they would say, Mr. Jean-Rony John Charles. But I was just going to make the point that the judge appears to have questioned the weight that he seemingly gave to this evidence, because at 513, which is the transcript of the hearing on the 5th of February, line 19, the judge explains that the relief he granted was predicated on the foundation that Jean-Rony John Charles's status was uncertain. Then at lines 20 to 23, says it was uncertain, and that was the reason purportedly based upon the indications made on his behalf that he had never left the Bahamas.
I'm sorry, what were you reading?
513, my lord, which should be the transcript of the hearing on the 5th of February, and lines 19 and then through to 23. The bottom line in my submission on this point is there was no reliable evidence that Jean-Rony John Charles had never left the Bahamas. What was asserted in Miss John Charles's affidavit was apparently inconsistent with the fact that 6 or 7 earlier travel documents had been issued to Jean-Rony John Charles.
But then it wouldn't be unlawful for him to depart and come back to the Bahamas if he had travel documents?
My lady, again, speculation, but the fact that more than one has been issued, one assumes they would be expire after a period of time, hence the need for further ones.
Yes, but if he had travel documents to travel outside the Bahamas, would they not authorise him to return?
My Lord, yes.
Well, how does that feed into Section 26?
Well, because we're talking about the fact that he has not at the point of time, it's common ground, got an extant travel document.
No, but in order to invoke Section 26, if that is the power, and we don't yet know because the government hasn't told us what power they purported to exercise, but if it is that power, then
but my Lord,
what will the travel documents tell you?
My Lord,
they may tell you that he had the ability and may have gone abroad on prior occasions, maybe years ago as a little child with his mother, and come back again. But how does that support the exercise of a Section 26 power?
Well, because if he had re-entered the Bahamas and landed in the Bahamas without such valid travel document, which one assumes, given that 6 to 7 have been issued in the past, they are not. There's no single travel document that is extant at this point in time. No. Then that would give rise potentially to power to detain and remove under Section 25.
But the travel documents wouldn't do that. You have expired travel documents. That tells you that he had the authority to leave and come back to the Bahamas on certain occasions. What the government would need to know is that he went out on another occasion and came back in unlawfully. Yeah. So what have the travel documents to do with it?
The travel documents are an indicator that what is asserted in Miss John Charles's statement should not have been taken at face value as it was by the judge. That's the forensic point. And I say that is an error that we see the judge fall into on numerous occasions where he simply asserts that there are undisputed facts when the respondent was not afforded an opportunity to take issue, address or challenge these facts that are the building blocks for the relief.
You have had an opportunity now to say there is a route by which we can establish that it might have been lawful and hence not a breach of his constitutional rights as found by the judge to have done what we did. That there is a mechanism by which a person can be picked up in the street, detained, flown to Haiti and left there without a deportation order or without the approval of a minister or the Governor General. Now, what is the legal route by which you say this might not, we might have been able to show that what happened to this person was not a breach of his constitutional right?
My lady, it is Section 25-26 allied with Section 9, power of arrest, and then the carve out in the Constitution for actions being taken by anything lawful means of controlling immigration. And that's what's set out in the Court of Appeal, in the Respondent's skeleton argument. That's one of the grounds of appeal that the Court of Appeal don't determine. And my learned friend took you to it. It was set out as Scenario 1, Scenario 2, Scenario 3. I'm here dealing with what was called Scenario 2, which is Section 25, Section 26. I think Scenario 3 was deportation.
But it wasn't deportation.
No, but certainly on the evidence, there was no deportation order that I'm aware of, and the government relies on. But this goes to Lord Hodges' point that well, why hasn't the government clarified the position? With the greatest respect, it is for the appellant to say whether he was the person that was stopped and questioned detained and removed in September 2017. The government has produced, in the habeas corpus proceedings, has produced the return that says we have stopped, questioned, detained and removed a person that gave his date of birth as X, his nationality as Haitian, and that person has been removed. The affidavit then says a different date of birth, different name, and purports to a different nationality. It is for the appellant to explain those discrepancies. It's not for, in my submission, the respondents to effectively link the person purporting to be the person whose treatment is described in the return with the appellant in these proceedings. And it would be the easiest thing in the world, one imagines, for the appellant to have produced an affidavit saying, I've seen the return, I was the person, full stop. He hasn't done so, and that's a point in the Court of Appeal. That was a point in the Court of Appeal where they said that identity was at large at first instance. The judge ought to have dealt with it. Identity remains at large in the Court of Appeal, and that's the basis on which the appeal was upheld.
And that's still so, is it?
Sorry, my lord.
That's still the position, is it?
Yeah, my lord, yes. And we appear in front of your lordship's board where that point, the link between the person whose treatment is described in the return and the appellant in these proceedings has not been joined. And that's not for the sorry, my lord.
So you say that link could be made were the appellant to make a witness statement confirming that fact.
Well,
you say that's what's missing.
Well, there would then be, if the appellant put in that evidence, then we may have arguments about admissibility of fresh evidence. But assuming the appellant gets over that hurdle, then I would be saying, well, we need to test that evidence as we wanted to test the evidence. So at first instance, but we're not afforded the opportunity. But I'm saying at the very least that is a surprising omission.
But the schedule described him as Jean-Charles Jean-Rony, I think. That's been pointed out to you by Mr. Fitzgerald. I mean, where did the government get that information from? If they were expelling, are there many Jean-Rony, Jean-Charles resident in Bahamas?
Well, one assumes they would have got that information from the person they removed. But my lord, that doesn't from the person that they removed.
Or Clotilde's affidavit, because the return was in response to the habeas corpus application.
Yes,
you were saying, well,
but I think the date.
We don't have your brother.
But I think the date. Well, I don't think they could have got the information from the affidavit because
the date's a list of.
Oh no, of course,
it's prior to that. But my lord, yes, and that's a point my learned friend rightly draws attention to. But we've got the return, and let's move to the return to the writ because. This is signed, and it has never been said, A, that's not my signature, or B, the information that is given there is incorrect. Mr. Fitzgerald this morning has said for the first time his instructions are he just simply gave the wrong date of birth. Well, that's not good enough. I mean, with respect, quite a bit of evidence has been given from the bar.
Oh, yes, yes, on both sides.
My lord, I'm certainly not giving evidence. What I'm trying to do is, and I appreciate maybe the distinction is, I'm trying to highlight what avenues of inquiry would have been carried out had there been a fair procedure followed. I'm not purporting to give evidence.
Yeah. I see the time. We'll adjourn now and resume at 2 o'clock. And I just comment that there is I certainly am feeling a sense of unreality about all of this. And well, perhaps you might reflect on that.